During her confirmation hearing, the judge that the repugs have ramrodded in, the dumb skank Amy Coney Barrett, was asked if she agreed with the late Justice Antonin Scalia's that the Voting Rights Act was a racial entitlement. Barrett, who has said his judicial philosophy is the same as hers, declined to answer. If she indeed shares Scalia's views of the Voting Rights Act, the Supreme Court is likely to embrace an ideal that would destroy much of the anti-discrimination law, that race-conscious and countermeasures against discrimination are themselves discriminatory. Scalia made his infamous racial entitlement statement during the oral argument in Shelby County v. Holder, the 2013 case that eviscerated the Voting Rights Act. Section 5 of the Voting Rights Act required states and localities with a history of discriminatory voting practices to submit to any changes to the federal government for pre-clearance before implementing them. Practices that were retrogressive, meaning that would put voters of color in a worse position than in the past, were prohibited. This mechanism was affirmatively anti-racist. It stopped the discrimination before it could start making the VRA the most effective civil rights law the country has ever known. Republicans, however, assailed the pre-clearance regime as of the regime as providing special treatment to black voters and other people of color. In 1987, the Reagan Justice Department lamented that Section 5 was being used to provide a guaranteed minimum floor for minority electoral success in Shelby County. Before the case reached the Supreme Court, a judge on the D.C. Circuit Court of Appeals had argued that Section 5 mandates the race-conscious decision-making inconsistent with the Reconstruction Amendment's commitment to non-discrimination, referring, with irony, to the 13th, 14th, and 15th Amendments, which are ratified to guarantee black freedom and equality. A number of groups made this argument in front of the Supreme Court. The Libertarian Cato Institute, for example, had claimed that Section 5 denies equal protection of the laws by providing the legal guarantees to some racial groups that it denies to others. The Supreme Court ultimately ended federal pre-clearance 5-4 by striking down the coverage formula that determined which jurisdictions were subject to review. The Chief Justice John Roberts concluded the formula no longer spoke to current conditions. Our country has changed, he wrote. The notion that America is essentially post-racial and that focusing on race will take us backwards and not forward is central to conservative legal ideology. The commitment goes far beyond Shelby County. It undergirds a comprehensive legal strategy aimed at dismantling the most significant pieces of anti-discrimination law won during the civil rights movement. Take the still standing Section 2 of the Voting Rights Act, which allows plaintiffs to sue over discriminatory voting procedures. It prohibits intentional discrimination, but also any voting practice that results in a denial or abridgment of the right to vote on account of race. Congress added that language to the VRA in 1982 as a rebuke to the Supreme Court, which 2 years prior had held the act applicable only to international discrimination. The legislative report accompanying the 1982 amendment explained that Congress felt disparate impact liability. The results test was necessary to get at the key question of whether voters have had an equal opportunity to participate in the political process and to elect candidates of their choice. Disparate impact liability is a critical tool in the struggle to root out racism and create the equal opportunity. First, most people who discriminate on the basis of race have never learned to hide it. Disparate impact law allows the victims of such covert discrimination to seek justice without having to prove that what was hidden in the perpetrator's mind. Second, everyone harbors some amount of implicit basis that can affect decision-making. And third, disparate impact liability can readdress structural discrimination systems and standards that may seem unbiased by that bacon disadvantage based on past societal discrimination, and it does work. Civil rights lawyers have used Section 2's results to test to work a revolution in black and brown political representation. In particular, they attacked districting schemes that diluted the voting power of the communities of color. The packing of these voters into as few districts as possible to limit their influence, the cracking of communities so voters were dispersed and unable to exercise collective strength, and the use of at-large elections that privileged white majorities who voted against candidates preferred by voters of color. These lawsuits won maps that created the majority-minority opportunity districts where these where these communities finally had a shot at electing their candidate of choice, and thousands of black and brown candidates have been able to win office as a result. These revised maps were race-conscious remedies for discrimination. Critics quickly moved to cast them as racial quotas. In the 1990s, the Supreme Court repeatedly struck down opportunity districts as unconstitutional. Racial gerrymanderers applying the 14th Amendment, again without irony, to reduce black political power. In a 2006 case, Roberts wrote about the creation of the Latinx opportunity districts. It is a sordid business. This divvying us up by race. In 1994. In a 1994 case, Justice Clarence Thomas decried the involvement of the federal courts in dividing the nation into what they call racially segregated electoral districts, objecting that they contribute to the racial balkanization of the nation, and concluded that the Voting Rights Act shouldn't apply to redistricting at all. Justice Neil Gorsuch indicated in 2018 that he agrees. The results test still stands, but it is in the crosshairs. Critics say that the test gives race too much consideration in the crafting of election rules. Even as people of color continue to face blatant voter suppression and are disproportionately unregistered to vote, subject to voter purges, and more likely to have their mail-in ballots rejected, they argue that Congress lacked constitutional authority to enact the results test this term. The Supreme Court will consider a case from Arizona that presents an opportunity to limit or even invalidate the results test. And this is just one front in the battle against disparate impact. In 2009, Scalia wrote a concurrence that made a frontal assault on Title 7 of the 1964 Civil Rights Act, which prohibits the non-job-related employment standards that have a disparate impact based on race or another projected characteristic. He wrote that the constitutional guarantee of equal protection prohibits the federal government from requiring employers, as he put it, to evaluate the racial outcomes of their policies and make decisions based on because of those racial outcomes. In 2015, the Supreme Court narrowly upheld the existence of disparate impact liability in the Fair Housing Act 5-4. Two of the justices in the majority, Anthony Kennedy and Ruth Bader Ginsburg, are no longer on the court, and the 45 administration has just released new regulations that could give it a reason to overrule this case. 45's Justice Department is also pushing lawsuits against Harvard and Yale to overturn a 2016 ruling that preserved affirmative action in college admissions. 45's Labor Department is investigating Microsoft for its pledge to double the number of black senior employees last month. 45 issued an executive order banning diversity training that he says teaches divisive concepts for government employees and federal contractors. At the Vice Squadron debate, dumbass Pence denied in the existence of systemic racism in America and implicit bias in law enforcement. We should not be surprised by this legal and cultural attack on the race-conscious remedies for discrimination. Many people would rather not talk about racism frequently in our history when we have made progress toward racial equality and particularly black empowerment. Much of our nation has turned to what they call so-called colorblindness and portrayed remedial measures as racial favoritism. A 6-3 Supreme Court that embraces this ideology could wipe out disparate impact liability and affirmative action. Worse, it could weaponize the Constitution to destroy the racial justice priorities of a new Congress. The Voting Rights Advancement Act, a bill aimed at reviving Section 5, the Green New Deal, with its targeted public investments in frontline communities of color and federal funding for historically black colleges and universities. But closing our eyes to racial inequality will not make it go away. We must tackle this head on, and that means being willing to employ the race-conscious policies and legal remedies to achieve the true opportunity for all people. We need a judiciary that currently understands this. So if you like the video, give the video a like and subscribe to my channel, Rambin Mike, and also hit the notification bell so that you'll be notified when a new video comes out, and thanks for listening.